This is the Legal Forum. Subscribe and share the channel. So for today we have to talk about international law. And international law, we have to talk about uh, the introduction of international law. Basically, the introduction. So I urge you to subscribe and share the channel. This is international law 1, basically, and I want you to understand that, however, we have the municipal laws that we follow as a country, as Uganda, but also you have to understand that even Uganda, as a state, they go ahead and they make laws. Different states, they make laws and they follow those laws. So they will agree to make laws, those laws which will help them to deal with other countries, because it is not the mere of moving from one country to another, or uh, getting in touch or in relation with other country. There must be a law. These laws are the treaties, the conventions, the general principles, the customs, and many others. So in this way, by definition, they say that international law, these are body of rules, principles, and agreement that governs relations between countries and other international actors. So other international actors, these are the ICJ, the United Nations, the International Criminal, the International Criminal Justice, and many more. You have to understand that international law has existed for centuries. It is not only that international law is here for recent, but it has been in existence for for many centuries. And in ancient times, where we could see the kingdom and the empire made agreement and trade, these people could base on the customs, they could base on religion and mutual understanding. You get? So international law has existed for so long. So in 17th century, we see that a man called Grotius Hugues Grotius wrote a book, De Jure Actuopacis. De Jure Actuopacis. He argued that nations should follow legal rules even during wars. Now, for him, saying that nations should uh, should follow the legal rules even wars, because now in 17th century, beginning from the 16th 1625 to 1700, the modern laws, all the modern international law had developed, and in this way they could now strictly follow the legal principles or the legal law, other than the mutual understanding and whatever. So for him, he said that nations should follow legal rules even during wars, and he was named the father of international law. So we see in 1945, the United Nations was created basically to promote peace and unity, um, because of the past wars, the two world wars. And even for those who know football, In 1930s, they created, or they brought up the what we call the World Cup, and the World Cup basically was to promote unity among uh, the countries. And for you who know, Uruguay was the first country to win the World Cup. Being that the reason why the football is there to promote unity. So World Cup was created to promote unity among the states. So after the World War II, international community recognized for a stronger rule the United Nations. So that is the background. But for now, for you to understand, actually, let's first talk about some of the schools of thoughts who talked about international law. Let's start with the naturalist school of thought under Aristotle, Jefferson, Scott, Socrates, and Plato. So, for these people, for them, they say that there was certain immutable laws or natural man's job was to search for and discover them. Law will be varied for all nations and for all times. So for them, they argued that even though we have the municipal laws, but being that we are in a global environment, that a person who is far can even detect what is ahead of his nation. So a man has to go ahead and search for jobs and discover those laws that are attached to the same. And the Roman great lawyer Cicero, for him, he said that law will be varied for all nations and for all time, that the law will be always valid for all nations and all times, which means for him, he he recognized the international law, same as the Aristotle, Jefferson, Socrates, and Plato. This is the naturalist school of thoughts. Now, positive school of thoughts, for them, they oppose it. They said that international law are created by the will and concern of sovereign states. So, being that the sovereign states are there, so they will sit down and create the law in their will. So that is uh, the positive school. This means that the law is made by the authority, and the law is then accepted by the states, the member states, through the moral principle. The moral principle you can, the moral principle you can uh, marry it with the factum servanda, which means the principle of good faith, that these people will rely on good faith principle, the morals and whatever. So in this way, that's how the school of thought talked about what we call uh, international law. Now, let's look at the sources. As international law is concerned, it has the source. Where does it come from? To understand clearly the international law, what could come into your mind? How does it exist? Now, one, we have what we call treaties. Treaties are made by the member states. They sit down. You will see what we call the lawmaking treaty, how they make that treaty. I will explain that in another video. But treaties are made basically. These are different terms urged, urged by the member states. They set the law and they must follow the law. So once you breach the law, then you face what we call sanctions, or you face any available, they go for any available remedy. So that is what we call a treaty. We shall discuss more in another video. We have customs. Customs are basically uh, the the way of doing thing that is immemorial in nature, that something have been happening. Yes, we've been doing this for us. I may give you an example of Saudi Arabia. Uh, they have a custom that for them they cannot allow, or for them they they don't eat this, they don't do this, and they have done that for so long. So there is no way you can come and say now Saudi Arabia you have to change, you have to do this. No, they have their own custom, as well as Africa, as well as Asia, as well as Europe. They have their custom. We have the general principle. The general principle, we have the principle of good faith, pacts and servanda, that you have to act in good faith. Law is always acted in good faith. So there is no way you can come out and force something to happen. Pact sant servanda. Oh yeah. So far by now, I want to explain some of the key terms. Key terms you have to understand while grasping international law. One, we have to understand what we call a state responsibility. So the state responsibility, the state is responsible for anything that is made either by the member of the state or the state itself. I may give you the example of what happened in DR Congo when Uganda had a mission, the UPDF mission in Congo. They had went for peacekeeping, but they ended up what we call stealing timber, or involving in timber stealing. And the court came out and said that Uganda has to pay for that. So Uganda is responsible, or Uganda was responsible for what happened. So that's what we call the state responsibility. Let's talk about recognition. Now, recognition, it is in two ways: the de jure and de facto. Now, de jure is where the state is recognized by the law, and it is fully recognized. I may give you the example of the South Sudan of 2011. It was created and it is known by the members of UN that South Sudan, it is created and it is there, it is the member, it is to be recognized. And you have to understand some different examples where you have to understand that do you know that China has never recognized Taiwan? Has never recognized Taiwan. You have to know that even now, Iran has never recognized Israel as a full state. So the recognition is in that way, how other states recognize you, or how the law recognizes you. You understand? So thank you for watching.